Hello, everyone. This is Samantha from the law offices of Samantha Wolfe, and I'm here today with Connor. For those of you who have been following our YouTube channel and our videos, Connor Burns is a Dickinson law student who is externing here at our office, and Connor's been helping us with some of our marketing materials. And so I think, Connor, this might be our last joint seminar. I think we've done 3 total, so I think this might be our last one. So we're glad to have you back. And today we're going to talk about do-it-yourself estate planning and some of the pros and the cons and why it's important to have a legal advisor. So I appreciate you being here. Thank you so much. We'll get a law student, soon-to-be attorney's perspective on it. So we appreciate the effort that you've done. I'm going to go ahead and share my screen so we can pull this up. Right. All right, so the topic for today is DIY or die trying, the truth about do-it-yourself estate planning. And like I said, Connor was kind enough to put together this presentation. So Connor, let's dive in. What we're going to cover today is what is DIY planning, reasons people may opt for that type of planning. Usually it ties to cost, convenience, and maybe people perceive it as being a simpler way to do their estate plan. We're going to talk about some advantages, some potential pitfalls, when you might want to consult an attorney, practical steps for those who are doing it yourself and want some guidance, and then we're going to have some question and answer about frequently asked questions that people have about it. So let's talk about it. You, I know, did a lot of work putting this together. Tell us what we would consider do-it-yourself estate planning.
Yeah, so do-it-yourself your estate planning is essentially, you can either go online or you can find other physical resources that would allow you to prepare documents such as wills, powers of attorney, maybe even a trust for yourself and get those documents signed so that you might have them in place. There are other software programs that you might be able to use, just kind of fill in the blank paper forms. It's essentially just so you can do all this yourself without consulting the attorney is the idea.
So it almost breaks down into 2 categories. So the first category is obviously like looking for online support. Like we talked about some of those form providers that you can Google. Sometimes you can get those drafting software. But I think another category of this that people often do is they might just handwrite their will. And so I do get that question a lot. I actually got it last week where I had an elderly client who came in for his own planning and he was talking about his dad's planning. And he said, well, my dad just hand wrote his will and signed and dated it. So we talked about whether or not that was an effective will, the pros and the cons of that. So I almost think of it as 2 categories. I think of it as someone who just writes their own will, could be handwriting or typing their own will. And then the other subset would be people who rely on many online sources that you can find, some forms that way. So I think of it in those 2 categories as far as do-it-yourself estate planning. Let's talk about why people might want to do it yourself. So talk us through the 4 reasons when you were doing your research that you found people might want to do it yourself.
Yeah, so what I found was cost saving advantage, convenience and speed, sometimes perceived simplicity, and then a sense of control or privacy. So as for cost savings, attorneys' fees can be high at times. So online tools, or as you had said, writing it yourself, is often a fraction of the cost. Some templates are free or under $100, and then again, if you write it yourself, obviously that's free. So we have also the convenience and speed. You can complete this at home and on your own schedule. So if you may work or travel, you can, write your own will, write your own documents whenever you have free time. So some clients might think that this is a little more simple than going to an attorney. They might not think that they might need complicated estate planning. We'll get into some of that. And then sense of control. We I mean, sometimes clients don't want too many people to find out about their financial situations, what kind of assets they may have. So disclosing that to an attorney or maybe a financial advisor might be a little uncomfortable for them. So this is when a client might go to the DIY route.
So let me talk a little bit about that cost savings, because I think you're right. I think people are like, well, I could do it online and just get this form that's under $100. And that is true, because there's no way getting around the fact that when I meet with a client, I meet with them initially to figure out what they want in their will. And then I'm going to at least meet with them one more time because I go over the document with them. And then I'm there when they sign. And then we set that up in our office for a couple of reasons. So the first is that a lot of times people want to meet with an attorney. If they're going to pay for a law office to do their will, they want to talk to the attorney. But the secondary and actually more important reason that you meet with the attorney in our office twice for the initial consultation and for the signing is because one of the things that I'm doing in my appointment is I'm determining capacity. So capacity, when you're figuring out if somebody could actually sign a will, is a legal determination. And so when I'm meeting with a client, the main reason I'm in there is to actually determine, do they have legal capacity? Usually I can do that by just talking and having everyday conversations with people. I don't typically have to say, who are you? Do you know what year it is? Do you know who the president? All of that is. Just by talking to someone, you can normally determine that. And I think that that's a real benefit that people miss out on when they do it themselves, because it opens up, and we're going to talk about this in some slides a little bit later, but it opens you up for a will contest. Because if you do it yourself and you don't have somebody there making a legal determination about capacity, the question becomes whether or not you had legal capacity at the time you signed. So I wanted to address number one there. Number two, the convenience and speed. We run into that all the time. We can draft it really quickly, but because I'm the only attorney in the office, getting people in for the initial consultation and then for the signing, sometimes there's a little bit of delay just because of my schedule trying to fit all the clients in. I would say those number one and number two are what I see in a lot of my appointments, is just trying to cut down on costs and trying to do it as quickly as possible. A lot of times that's because maybe people wait and then they might get a health diagnosis, and so then they want to hurry up and do it before their health would decline.
Mhm.
All right, let's talk about some advantages. So we talked about some of the cost savings. Talk to us a little bit about that.
Yeah, so the DIY route might be a little more budget friendly, considering some of what we're talking about here is just completely drafting the document from scratch yourself, maybe on a piece of paper. So that being completely free, we probably want to touch on this. Some people with minimal assets, few beneficiaries may find the DIY route sufficient. If you compare the typical DIY cost, which depending upon if you do it yourself or if you buy a form, is likely under $200, to attorney's fees, which could be anywhere from $300 to $1,000 plus for your more basic documents. It might be acceptable for younger individuals, but that's kind of circumstantial because we have to deal with things like guardianships and things of that nature. So we'll get into a little bit more about that because it does get a little complex. And then you're saving costs up front. So if you're confident your estate planning is simple, you can save significantly on legal fees, but we'll get into a little bit more again moving forward. You might end up having to backtrack later on to get an attorney because what you did may not be effective if you didn't do it correctly.
Yes, because unfortunately, every state in the United States has a little bit different rules and laws as to how to actually execute a will or those basic estate planning documents. And that never became more apparent than at the time that we were dealing with COVID and being able to execute documents, because when we had people in nursing homes and we had lockdowns, it was a question of, well, how do we execute these documents in a way that complies with Pennsylvania law? And we'll talk about this in a minute, but like a will, you don't actually have to have it witnessed or notarized. There are reasons you might want to witness and notarize, which we'll get into. But when you start talking about powers of attorneys, there are a little bit more stringent requirements about that execution. So in Pennsylvania, sometimes people can do their own will, but there are other documents, the powers of attorneys that you typically do with your will. There's a little bit more as far as the execution requirements. And so people don't often realize that. And so I want to make people aware that actually the will is the simplest document you can do. The others are a little more complicated. Let's talk about convenience and speed. Yeah, I'm not available 24/7, unfortunately.
Yes. So, a lot of the online tools, and then, I mean, if you draft it yourself, that's a 24/7 thing. You can do it whenever you have free time. So, uh, you need to coordinate schedules with an attorney a lot of the time, as we had talked about. It is possible to finish in a single day if you have all the info ready, but that really depends on the attorney. Here at our office, I mean, we meet multiple times, just kind of to run through and explain documents, and then also to assess capacity. So if for at least our office, that really doesn't go well for here, but other offices do it differently. So a lot of the DIY route, they usually have user-friendly interfaces. They have some Q&A to help guide you through some of the basics. And then sometimes it's less intimidating for clients because I mean, I struggle with this at times, using a lot of legalese to explain things because it's just the way I was taught. So I figured everybody else would understand it, but sometimes that's not really the case. So these DIY tools might be a little bit more understandable for clients depending upon the attorney you have.
What's interesting to me is that when I meet with clients, I would say 90% of the time when I'm doing my intake, like if somebody's doing a will, I might say, well, who do you want to serve as your executor, and kind of running through the different roles and positions and the distribution that someone would want in a will. I'm surprised how often people aren't sure. And so it's interesting to me. I mean, certainly if you come into an attorney's office and you know exactly, and you're just listing it off like, this is what I want, this is who I want, all of that, then in theory, it doesn't take a lot of time to put it together. But at our office, some of the delay is our clients. They're indecisive. You know, they want to think about it. They might want to talk to some individuals about that. And they might have questions about, well, what happens if I name two people? Or is it advisable to name multiple people? And so it's always interesting to me that you're right. It does allow for faster completion. But sometimes I think our clients are what slows down the process too, because they need to contemplate what they want to make sure they feel comfortable with it. All right, let's talk about perceived simplicity.
Yeah. So our first point here is smaller asset pools. So some individuals feel as though the amount of money or the assets they have don't require or necessitate more complex planning that they would think would come with hiring an attorney. Those with fewer assets might be able to get away with basic planning documents. So that's kind of their thought process there. Time savings, this simplicity means less time needed to accomplish whatever estate planning goals the client may have. And then those with limited goals, fewer long-term care goals and considerations, those individuals may be able to accomplish whatever they set out to do with more simple planning, depending upon, goals and complexity. So it's important to note here that not every estate can effectively use such simple planning, and frankly, most cannot. So I would strongly advise you at least consult with an attorney, even if it's a free consultation, just to kind of get to know your situation, because it might be more complex when you kind of get into the weeds of it than any DIY tool may tell you it is.
I think there are a lot of hidden traps too. Like you may come in and say, well, I have a very simple estate plan, but I had a client last week who was like, but I want to give my one child the option to purchase the real estate, which is a common thing. This woman had two children, and she had a house. And so she wanted to give one son the option to purchase it. And she wouldn't have been able to do it herself with that will, because in Pennsylvania, there are some pitfalls. If you don't know how to draft that correctly, then you would have to get court approval in order to be able to do that. And so if she tried to do it online, she probably would have thought she had accomplished what she wanted. But then when it came time to administer it, would have been much more costly for her children to actually administer that estate, because all it took was us to know exactly how to do it, and it makes it simpler on the back end with the administration.
Yes.
Okay, advantage number 4, a sense of self-control and privacy. This we run into sometimes with clients. So talk to me about this.
Yeah, yeah, absolutely. So, individuals may want to keep their finances private. They might not want to disclose them to a third party. That would include attorneys or financial advisors. Templates or other online resources may appease some of these feelings of unease, but also there is the consideration of you're also kind of revealing these things to a third party technically, because I mean on a lot of these websites you would be doing that, you would have to, but you know then again the consideration is, well, I could just write it myself, which is another option. So here this may make individuals feel as though they are more in control of the costs, as many attorneys and advisors charge hourly for making for and this would increase clients' costs in order to do this kind of astronomically over time, depending upon how complex everything is. So clients may want more control over not only how much they pay, but also where their information is stored and who knows about their information.
Sure. The one thing I will say about it is that should feel empowered to, whenever you call an attorney's office, you can ask up front what the fee would be to do a will. We have people call all the time, and before they want to make an appointment, they want to know the cost. And that would be important. At our office, we do everything flat fee. When it comes to estate planning, we don't charge hourly for it. So our support staff would be able to say, okay, if you want a basic will, this would be the cost of that. That way you know up front. And then we don't keep track of hours. So you're going to meet with the attorney for the initial consultation and for the signing, and that you'll have that time to ask any questions, and that's all included in the flat fee. The other thing that our office does is we do typically send out an intake sheet that does ask for asset information, and I've occasionally gotten some questions or some pushback for that. The reason that we do that is you'd be surprised. The titling of assets or beneficiary designations, that always trumps the will. So if you have a jointly owned account, or if you have an IRA that might have a beneficiary designation, those assets don't pass through your will. So the reason that we ask those questions is to figure out what assets are actually passing through the will, and do we need to make any recommendations as far as updates to beneficiary designations or updates to the account titling in order to kind of fit in with your overall estate plan. So that's why we ask that question. If we have clients that don't feel comfortable disclosing that, then usually I just talk generally and I explain that if you have anything jointly owned or you have anything with a beneficiary designation, that's going to go to directly who you have designated or to that joint owner, just so clients understand what assets are actually passing through the will. All right, let's talk about some potential pitfalls.
Yep. So for this section, we'll go into compliance with Pennsylvania laws, inadequate or outdated documents, because that is also a concern, overlooking some critical issues, as we've kind of alluded to before, and risk of disputes or I'm sorry. Issues with disputes. Do you want to cut that out or?
It's okay. We'll go back and revisit it, Connor. Yeah, I think my guess is what you're talking about there is the risk of disputes. And then I was wondering if this is what maybe you were indicating. We have a lot of people that ask about joint wills. And so there's a lot of pitfalls online. If you can always do a joint will, but we always recommend that you make it your individual estate plan. So that's what I actually thought that was alluding to, is just making sure it was specific to you, which might not be what happens when you're online. So let's talk about compliance with PA law. I'll talk a little bit about this, about the execution requirements, because there's some misconceptions with that. So the first misconception that I get is that a will does have to be notarized. And it does not actually have to be notarized in Pennsylvania, as long as you have it. If I have somebody that has handwritten their will and then signed and dated at the end, that would be actually a valid will in Pennsylvania. The reason that we do certain additional things here at our office is it makes it easier on the administrative end. So a lot of the execution requirements that we use at our office are more to help with the administration. So for example, if you do have it notarized and you have two witnesses, the benefit is when you die and your executor's administering your will, you don't have to have two people come forward and say that is in fact my signature. If you don't have the notary and witness, then it requires more work when someone's administering it, because the executor has to take two other people that are going to confirm that that is the decedent's handwriting and signature. And so that's why we do it with a notary and two witnesses, because then what happens is we just send it to the courthouse, get the executor sworn in, and there's not all of those additional steps. So it would actually save money, because when we have to get, we call that like a self-proving affidavit, where you have to have two people say, yes, this is the decedent's signature, it can cost more. And so this allows the will to be valid when you pass away and not require those two witnesses. So that's why we do it that way. But I wanted to make sure everybody knows that you don't need witnesses or a notary in order for a will to be valid in Pennsylvania. Some other pitfalls that we see is that Pennsylvania is one of, I think, about 5 states that has an inheritance tax. So we always like to have a tax allocation clause in our will. And sometimes when you do it online, because Pennsylvania is only one of 5 states, the online program that you might be using doesn't always account for that. So if you think of it this way, if you have IRA money and assets that are passing through the will, where do you want the tax to be paid from? And so in Pennsylvania, there's an inheritance tax, so we want to make sure we're paying it where you wanted it to be paid from. And the best example I can give you is sometimes we might have charities listed in our will, and so we might say, oh, from an inheritance and an income tax perspective, we may want to allocate the designations differently because we can actually save some tax money. And we might have different beneficiaries on the IRA than we do in the will, and different percentages, and so we want to make sure we're having that tax allocation clause in there. So that's specific to Pennsylvania. And then there are some issues with elective share for spouses. And I wanted to talk about this a little bit because in a lot of what we do here at our office is we're trying to protect against nursing home costs. So we might actually have what's called a bypass clause in our will that says, I want everything to go to my spouse unless they're not, or unless they're in a nursing home, I should say. And then we want it to bypass. And so there are some elective share concerns there that you won't get that assistance if you do an online tool. And then if it's not done properly, then you have a question of, is it invalid or only partially enforceable in Pennsylvania? Is it opening up the executor to possible will contests? So that's important to make sure when you're doing compliance with Pennsylvania law. And when you're working with an attorney, you can make sure that they're following all the Pennsylvania requirements. All right, let's talk, Connor, about inadequate or outdated documents. I'll let you take this one.
Okay. So we'll first start with kind of one size fits all templates. So, you can go online and get forms. You can pay for forms. So these may not cover all the contingencies, like I had mentioned previously, guardianship for minors, alternate beneficiaries, beneficiaries that might be subject to inheritance tax, things of that nature. So changing laws, online forms, especially ones that you just kind of get off of Google and not particularly from one provider, may have tax codes or other statutes that might need to be updated. These laws, frequently update and change. So if you're getting a form from, let's say, 2023, it might have different implications, at least tax-wise, than it would, before, and in addition to that, other laws as well. So you might also have evolving circumstances. So things like marriage, divorce, birth of new children, changes in assets, large monetary purchases, things of that nature would really, change your estate planning. So that's something that, clients need to be aware of. So some consequences of some of these is heirs might be left without the ability to inherit. Documents would conflict with each other. documents would conflict with your actual wishes, and there could be ensuing legal battles over documents because of these issues.
Sure. So three things that most people don't think of to provide for would be, what if my spouse is in a nursing home? What do I want my will to say? If I'm having it go to children and it pays per stirpes, which means that if one child dies and it goes down the line, sometimes they have underage beneficiaries, so they need to name a custodian. And sometimes people don't think about that. And then thirdly, if you do have a beneficiary that would ever qualify for Medicaid or any Social Security Administration benefits like SSI or SSD, sometimes you want your will to say, well, if I do have a beneficiary that would qualify for that, then I want it to be handled in a different way so that beneficiary would still receive their benefits. And all of those do-it-yourself programs that you use aren't going to account for those situations. We also have a concern when it's a second marriage or a blended family, because if you are leaving everything to your spouse, we did a whole presentation about this, talking about blended families. If you just leave it to your spouse, and your spouse, after you die, goes and changes their will, it could potentially cut out people that you wanted to benefit. So we always like to have those conversations. And a lot of times, if you're doing it yourself, you're not thinking of those concerns, or the program that you're using isn't accounting for that. Oh, perfect. So this, Connor, should have waited till this next slide. So this kind of covers it. Everything with that we just mentioned here: guardianship for minor children, special needs beneficiaries, blended families, long-term care planning. So these are things that your do-it-yourself programs, or if you do it where you're handwriting your will, aren't going to account for these specific situations. The other one I mentioned previously in the presentation was an option to purchase real estate. So you want to make sure you have that in there as well, if you want those specific provisions in. Let's talk about risk of disputes or somebody saying it's invalid. So the two ways that a will can be determined that it's invalid is if there's undue influence that's exerted, or if you're saying that there's a lack of capacity. So those are the two cause of actions that most often families bring, and doing it at an attorney's office can help mitigate those concerns, because that's why we have the two witnesses. That's why we have the attorney determining legal capacity. And so if you don't have those protective measures, it does open your estate up for those causes of action. But Connor, let's talk about what you have on your slide here.
Yeah. So we'll get into ambiguous language. So vague distribution instructions could prompt family disagreements. So maybe a situation where you want to, you might have a blended family, you want to give it to, let's say, your children from the previous marriage, but you could run into an issue where you don't state that correctly. You just say my children. So it's a little bit vague. The distribution you might have issues with distribution at that point. So you'll have a higher likelihood of challenges. Relatives might contest the will if they suspect errors or unfairness. And even if there's maybe an error in earlier in the document, that might cause a relative later down the line to also suspect that there's issues further into the document, as well as issues with capacity that that could not bode well for that. So you could have probate delays and costs. So infighting between your family members could cause dearly for not only their wallets but for the court system. Court fights will significantly increase legal fees as well. And then we have an emotional toll on the family. So brewing family conflicts obviously is not good. These conflicts could cause stress around interpreting the decedent's wishes, and could leave a bad taste in your mouth, for lack of a better term. So these are concerns that we need to highlight going forward with this.
Sure. Let's talk about when to consult with an attorney. I think always, but tell me, Connor, what you're saying on this slide.
Yeah. So I think especially in DIY situations, it's important to get an attorney's point of view really prior to starting these documents because, as we had mentioned, there's a whole bunch of complexity. So, kind of getting into the slide here, as I said, prior to beginning work on these documents, an attorney could inform you about potential complexities of your situation, as we had said. Consulting with attorney will help you make a more informed decision on whether the DIY approach is more viable for you or whether or not your situation is complex and would necessitate an attorney looking into it. So if an attorney has stated that the DIY option is a viable means forward, you can pretty much rest assured that going forward with DIY wouldn't be too much of a concern. But again, if you have any questions, I would highly suggest seeing an attorney about those.
I think anytime you're engaging an attorney, it's just like any other service. You need to meet with them and make sure you feel comfortable. An attorney that is doing their best interest shouldn't be trying to sell you something more than you need. So we always tell clients that we want to keep it as simple, your estate plan as simple as we can while accomplishing your goals. So one of the things that we might do is we might say, here are some other options, but ultimately it's the client's decision about what type of estate plan they want. And so you need to make sure you're meeting with an attorney that is giving you different options, because usually, just like anything in life, there's multiple ways you can accomplish it. So just find somebody, connect with an attorney that will have a dialogue, an open discussion about this is your situation. There are several options of how you can deal with it. Some of them may be more simple, some of them may be more complex, and here are the pros and the cons, and then lets you decide, puts you in the driver's seat and says, you pick how you want to handle your estate plan. That's really the ideal when you're meeting with an attorney. Practical steps for DIYers who still want some guidance. So, Connor, tell us about some research stuff that you can do to make sure. So, walk us through that.
Yeah. As we had said, I recommend that not only you might consult with an attorney, but you do your research on the tools that you may want to use to DIY your own documents. So not all DIY tools are created equal. I wouldn't just pick a tool with good reviews. I would make sure you choose a tool that you understand, because here at our office we like to do two appointments, not only for capacity reasons, as we had previously said, but also to make sure the client really understands their documents and what they're signing. Not only picking something with good reviews, but something that you really understand to a degree that an attorney might be able to provide that understanding to you. So after researching tools and consulting with your attorney about the situation, during the attorney, the consulting with the attorney, I'm sorry, you might ask if the DIY plan is a good choice. Ask about the complexities of your situation in particular, and whether or not the attorney recommends a more personalized approach. You might want to also ask your attorney if they recommend any specific DIY tools or resources. Attorneys might be a little more tuned into these DIY resources, so it's good to kind of bring that to the forefront of that conversation. And overall, make an informed decision. If an attorney thinks that your situation could benefit from DIY planning, I would go ahead and make your informed decision as to what tool would be right for you.
Mm-hmm. And I guess my stance on it is that if you're thinking, oh, I could just write my own will and do my will that way, if you're thinking you can do that, then you shouldn't need any other tools. If you're thinking you need a tool to draft it, you're probably going to want to talk to an attorney, because that means that your situation is complex enough that you're not sure that you can write the provisions yourself. That's my rule of thumb, is if you think you can do it yourself and you're not going to those other sources, then do it yourself that way. But if it's something where you're relying on some sort of software or an online template, you probably do need to talk to an attorney, because there's a reason you don't feel comfortable just writing your own will. All right, let's go over some frequently asked questions. So, is a DYI will legally valid in the state of Pennsylvania? And we talked about this. Yes, generally valid under PA. It just has to be signed and dated. So, again, nothing saying that you can't write your own will or use any of those software type of tools if you want. It's usually that the situation or the circumstances or the provisions that you want to include are typically what's going to make it a problem for you because it's not specific enough, it's not addressing your situation. But a DIY will is still going to be valid in Pennsylvania. So let's make sure everybody knows that yes, you can do your own will and it's valid in Pennsylvania. So again, the reason that you're typically consulting with an attorney is because the provisions are a little bit more tricky or technical, or you have a situation or a certain beneficiary that you need to address. If my estate is small and straightforward, do I really need an attorney? And the answer is probably. Yes, you probably do. Because again, there are situations that involve capacity. If you want to disinherit somebody, do you have the ability to sign? You can sign by mark in Pennsylvania. And so a lot of DIY tools and software don't have that option. Talking about definitions, about what does Pennsylvania define children as? Does it include adopted or non-biological children? So that can all change the actual provisions that you put in the will. So even if you have a small and straightforward will, typically you do want to talk to an attorney. The other part of that is that if you have a small estate and it's pretty straightforward, maybe there are ways that you can avoid the probate process completely. Like maybe you can throw a beneficiary designation or a joint owner or do those type of things so that you don't even have to go through the estate administration process. And that's what an attorney is designed to cover in their appointments with you, is maybe we can even make it so that it's not subject to the probate process at all. An attorney can be really helpful for that. How often do I need to update my will or other documents if I go the DIY route? So Connor, I want you to go over this slide. I think I'm going to open it by saying that you're going to want to update your will as often as you would with an attorney. And our rule of thumb here at our office is every 2 to 5 years, you typically want to touch base with your attorney just to make sure that there are no changes that you want to make. But tell us, if you're doing a DIY, what's your opinion about that?
Yeah. So my opinion is to revisit those documents at least every 5 years, or in the event of a significant life event. So we would define significant life event as marriage, divorce, significant wealth increases, large monetary purchases. This could include homes, significant property, maybe a collector's item, some sort of really expensive car, birth of a new child, because then we have guardianship issues, and we would want to make sure that these children are 100% accounted for, and there's no there can be no discrepancy in thought as to if we intend to actually leave anything to these children. So some questions you may want to ask.
Before you move on, Connor, one thing I will add
yeah.
there is it could be like a health change, because then we're worried about long-term care aspects of it. So it might be a health change. Here, where my office is, we're really close to the Maryland line. So sometimes people move. They might move into a different state. So that would be another time. Or if you're retiring, that would be another time that you typically want to meet with an attorney just to make sure you have all of your estate planning documents in order the way you would want. Now you can go forward. I just wanted to add those couple.
Okay. Yeah, no, it's okay. So, moving forward, as you're revisiting your documents, I would say, ask yourself these four pretty simple questions. Does your document express your current goals? Your goals may have changed and evolved over time. So we want to make sure that that your documents still accomplish what you set out to do when writing them. All of your assets accounted for in these documents? Because, as I had said, significant wealth increases or large monetary purchases could change those. So you might want to revisit the documents again at least every 5 years to ensure that all those assets are accounted for. And then are all of my intended beneficiaries accounted for in this document? We touched on that a little bit with, marriage or divorce or birth of new children. And then were there any recent or significant law changes that this document might not account for? Now, this one is a little bit more complex and might have cause for concern, especially if you're doing it yourself. Legal research is something that I know I've been trained in over the past 3 years, and it's something that I still struggle with. So I would recommend, if you have to ask yourself whether or not the laws have changed, you might want to consult an attorney at that point.
I think that's one of the other benefits of using an attorney for your estate planning. One of the things that we do here at our office is we would notify our clients if there was a law change. Doesn't necessarily mean a client has to update their documents, but we would certainly let them know and say, hey, this law change has happened. And then the client would have the opportunity to meet or talk to us here at the office and figure out, does that change the estate plan? And so that's one of the other benefits of having an attorney. What if I have a family member with special needs? Can a DIY tool properly account for that? So the technical answer is yes, but we highly recommend that you seek legal counsel for any situation that involves a special needs individual. This is a whole area of law that typically you want an attorney that has some experience in that area, because they're going to talk about certain types of trust, special needs trust. They're going to talk about how you can properly leave assets to individuals that would still allow them to qualify for SSI or SSDI benefits if they would receive them. So meaning they'd get their inheritance plus they'd still qualify for benefits. If you leave an asset to a beneficiary that has special needs that is qualified for a benefit, it will jeopardize their benefit. And the issue with that is that normally when they receive an inheritance, it's only a specific amount of money, and then they'd have to reapply and qualify for that benefit. And that's very cumbersome when someone's already received the benefit. So if you have somebody that does have special needs that is going to be a beneficiary of your estate plan, absolutely you want to talk to an attorney, because they can go over things like Pennsylvania ABLE account as an option. They can go over first party or third party supplemental needs trust. They can always design language that allows the executor the ability to create a special needs or supplemental needs trust. So you just want to make sure that if you have a situation like that, that you are talking to an attorney. And in our intake sheet that we provide for new clients, we always ask that question is, do you have a beneficiary that would have special needs, so that we can make sure we're covering that for you. Do I need separate documents for powers of attorneys and living wills? This is where Pennsylvania becomes more complicated as far as the execution requirements, because in Pennsylvania, wills are real easy to do, but these power of attorney documents have a little bit higher threshold or more hurdles, I guess, for execution requirements. And in my opinion, they'd be even more important than your will. Your will, you've died, so you don't care where your assets go at that point. But powers of attorneys are while you're living, who has the ability to make decisions. And so that would be really important to have in place, because otherwise nobody can make those decisions, or somebody would have to apply to the court to be awarded a guardianship over you. So you want to make sure you have those documents, and they are separate from the will because they're effective while you're living. A will is when you die. Once you die, none of your powers of attorneys are effective. So we always recommend that every individual have not only a will, but a power of attorney. And like I said, my personal opinion is that those powers of attorney documents are even more important than the will. Connor mentioned here about how they can be for financial and for medical decisions. So when you're meeting with an attorney, the attorney will go over all of those documents and outline when they're used. What happens if my DIY will conflicts with a beneficiary designation or my retirement account or life insurance? So again, this is why we ask for asset information, because typically your beneficiary designations are going to supersede what you have in your will, and a lot of people don't realize that. And so you want to make sure that your beneficiary designations are fitting in with your overall estate plan. The other thing that some people do is they might name their estate as the beneficiary, and we typically in most situations we'll explain the reasons why that would not be advisable and why you'd actually want to designate beneficiaries on there. The way that the will can kind of come into play with this is if you've named an underage beneficiary, the will language where you're naming a custodian will typically say assets that are passing through the will or any non-probate assets that are passing through a beneficiary designation. If the beneficiary is underage, we're going to appoint this custodian. And so typically you want to make sure that your will allows for that custodial language covering those non-probate assets like retirement accounts and life insurance. And Connor's right here in his slides, financial institutions and insurance companies are legally obligated to pay out those assets according to the beneficiary designations on those accounts. So if your will has something different, but you forgot to update your beneficiary designations, that can be a problem. Anything else you wanted to add to this slide, Connor, that I didn't cover?
No, nothing in particular.
Okay. Does a DIY estate plan protect me from probate, or will my estate still go through probate? So I didn't think that this was a commonly asked question, but interestingly, in the last month, I've had multiple clients during the initial consultation say that they wanted a will to avoid the probate process. And the important thing to know about this is having a will doesn't avoid the probate process. If you have a will, whether it's a DIY will or whether it's one that an attorney has prepared, it's going to go through probate. That's what the process, probate is the process by which your assets get distributed according to your will. So you're only avoiding probate if you do things like a beneficiary designation, a joint ownership, or if you use a trust. So that's what Connor's talking about here when he's talking about pay on death or transfer on death designations or just a plain old beneficiary designation. That would also avoid probate. So that's why you want to talk to your attorney, because a lot of times clients come in and they want to avoid probate, but a will doesn't actually avoid the probate process. Will doing it myself save significant money, or is the risk not worth it? And like we talked about, it depends. Every person has to evaluate the cost benefit analysis. But what I will tell you is that Connor's right. The average cost of a DIY will is about $100 to $200. And if you work with an attorney, it can be anywhere from $200 to $1,000. So again, when you're calling attorneys or scheduling an appointment, always feel free to ask the office, can you give me a ballpark of what the will generally is? And then when you meet with the attorney, it's just figuring out what's the best avenue. Is it just a basic will, or do you need a little bit more? But my biggest concern is that people think by spending the $100 or the $200 on the DIY will save money. And in reality, most times it saves money now, but it might cost more on the administrative end. Can I create a trust by myself, or is that too complicated for a DIY approach? So I had a client about 3 weeks ago who came in and they had a DIY trust. And the problem is that it wasn't drafted. It wasn't doing what they thought it was doing. So whenever you're stepping in to dealing with trusts, we highly recommend that you consult with an attorney. That's a whole area of law that attorneys typically focus on, is trust planning, because they can be really complex. They can change the control or the taxation. They can change the creditor protection that you might get. Certain trusts offer more creditor protection. So we always recommend that you talk to an attorney when you're dealing with trusts. And we think that trusts are very helpful here at our office, but it has to be the correct situation. So again, when you're meeting with an attorney, part of what they need to do is evaluate your situation and see, is a trust something that would accomplish your goal? Is it possible to do a hybrid approach, create a DIY will and have an attorney review it? Connor, talk to me a little bit about this.
Yeah. So, yes, technically it is possible to do a hybrid approach. It may end up being more expensive in the long run than having an attorney draft the documents, as you would likely be billed hourly for such a review. I know that here at our office and quite a few offices now do flat fee, but that's only if they're writing your will. So if you were to come to them with another will and ask them to revise it, likely someone would charge hourly for that. So the average cost for an estate planning attorney hourly in Pennsylvania is anywhere between 150 to 650, depending upon where you go. If you go in Harrisburg, it might be a little more expensive. If you come to our office, it might be a little bit on the lower end of that scale. But if an attorney were to find errors or omissions in your DIY document, you may incur additional costs of the attorney revising those documents, or just flat out recommending that they were to start a new will from scratch, which would be even more expensive at that point.
Absolutely. Yeah, I think generally speaking, our flat fee for a will is lower than what my hourly rate would be. So if it would take me an hour to review it, it would actually have been less expensive to just do a new will. And that's just because we have our will templates that we use at our office that have our standard language in it. So it allows us to do it much more efficiently. Where if I have to review something, I'm reviewing it for what you've given to me, and there's no template as far as reviewing documents. So that's just typically, you're right, Connor, it usually is less expensive for us just to do a new will. All right, so in conclusion, the DIY route may be a good option for people who want really basic documents. They're in a pinch, maybe they can't wait to see an attorney. For more complex documents, or for individuals that have multiple businesses, might have a disabled or special needs child, might be a blended family, might have large assets, might want to have a unique situation. The option to purchase is a great example of that. Then you typically want to consult with an attorney, and you always want to seek the advice of a qualified attorney. Feel free to ask them questions about it, because again, usually any attorney is going to be really upfront about what works for you and what's the most cost efficient way to do that. The other thing too is that Pennsylvania does have a lot of great clinics where attorneys volunteer their time, like we do in our county Wills for Heroes, that sometimes will offer free will services for first responders or for veterans. And so if you're somebody who falls into those categories, you can always check with your local bar association. Sometimes there are ways that through the community outreach, you can obtain documents where there's no cost, depending on your circumstances and situations. And that would still be better than a DIY will, because attorneys are there actually drafting it. They're just volunteering their time to give back to the community. So that's if it's a situation where you want to actually meet with an attorney, but you meet those certain groups, check with your local bar association. All right, Connor. Let's close by just telling everybody that you can always call our office to schedule an initial consultation. We're always happy to review any wills that you might have to see if you need to make any changes. Any other comments you have about DIY planning?
Well, personally for me, I would just ensure that you know what the document is that you're signing, understand the language in the document, make sure you do your research. And if you're doubting yourself, if you're asking questions, if you're doing research, you don't really know, what your document may say. I would really, really caution people to go and consult an attorney about those issues. These things get complex. I've had some formal legal training, and I cannot draft a trust on my own. So I can only imagine how difficult it might be for other people to do so. So I would absolutely recommend going to an attorney for these sorts of things.
The best analogy I can give people is that when you have certain health symptoms, we all jump online, right? And we Google our health symptoms, and WebMD comes up with something. But you still go to the doctor to be treated, right? Like you're not at home trying to figure out at-home remedies to treat strep throat. You have to go to the doctor for them to be able to prescribe the medicine. And I think that's the best analogy that I can give. You can do research. I always encourage people prior to meeting with me, do research, come in and ask questions about what you find. But at the end of the day, you want a professional that has paid for legal training, has gone to law school, and has really immersed themselves in the study, just like you would want a medical doctor that is experienced in that area to be treating you. So that would be my recommendation for everybody. Connor, thank you so much for joining me today to talk about these topics. Anybody who has questions or concerns, you can always contact our office at 717-655-2676. And this is our last video, Connor, that you and I will be doing together. I know you're working on some other ones for us, but we appreciate your time putting this together. Thank you so much for being here.
Of course.
All right, take care, everybody. Bye-bye.